For 3 years, Sandra drove her mother to every doctor's appointment. She managed the medications, handled the insurance calls, coordinated the home health aid, paid the bills when the autopay failed, and spent most of her weekends at her mother's house, doing the things her mother could no longer do alone. She did all of this without pay. Her 2 siblings, both living in different states, sent cards on holidays and called occasionally. They appreciated what Sandra was doing. They said so regularly. Then their mother needed to apply for Medicaid, because the cost of care had finally exceeded what her savings could sustain. And during the Medicaid application review, something surfaced. Over the past 3 years, Sandra's mother had transferred approximately $48,000 to Sandra, money Sandra had used for her mother's groceries, her co-pays, her household supplies, and, when things got thin, to partially offset the income Sandra had lost by reducing her hours at work to make the caregiving possible. Without a written agreement, without documentation, without any record that established these payments as compensation for legitimate services rendered. Medicaid's reviewers looked at $48,000 in transfers to a family member and saw something very specific: gifts, disqualifying transfers, and the penalty period that followed delayed her mother's Medicaid eligibility by months, during which the family scrambled to cover a nursing facility cost that Medicaid should have been covering. Sandra had done everything right as a caregiver. She had done almost everything wrong as a planner. Today we are going to talk about the document that protects both the caregiver and the care recipient. It is called a personal care agreement, sometimes a family caregiver contract, or personal services contract. It is one of the most underused tools in elder care planning, and it is directly relevant to millions of families where one child has taken on the primary caregiving role, formally or informally. We are going to cover what it is, what it must contain to be valid for Medicaid purposes, what the tax picture looks like, how it relates to sibling dynamics, and how to get it done right. This content is for educational purposes only. It is not legal, financial, or tax advice. For your specific situation, please consult a certified elder law attorney. You can find one at NALA.org and a qualified tax professional. Let's start with the problem the agreement is designed to solve. The problem without the agreement. Most family caregiving happens informally. An adult child steps up, gradually takes on more responsibility, and at some point, the parent begins helping out financially, paying for the child's gas, their meals, eventually something closer to real compensation for real time spent. This feels natural. It feels like a private family matter. And in many contexts, it is. But in the context of Medicaid planning, informal financial transfers between a parent and a caregiving child create a specific and serious problem. Medicaid has a 5-year lookback period. When a senior applies for Medicaid long-term care benefits, the state reviews every financial transfer the applicant made in the preceding 60 months. The rule exists to prevent people from giving away assets to qualify for Medicaid. Any transfer that cannot be documented as payment for legitimate fair market value services or as an exempt category of transfer is treated as a gift. And gifts create penalty periods during which Medicaid will not pay for care. Without a personal care agreement in place, payments to a caregiving family member look exactly like gifts. The child can explain, truthfully, that the money was compensation for 3 years of care. But explanation without documentation is not evident. Medicaid reviewers work with documentation, not with explanations. And the families that get caught in these penalty periods are almost always the families where the caregiving was real, the sacrifice was real, and the intention was completely legitimate, but the paperwork was never created. The personal care agreement is the paperwork. What a personal care agreement is: a personal care agreement, also called a family caregiver contract, elder care contract, or personal services contract, is a written contract between a care recipient and a caregiver that establishes a formal, documented employer-employee or employer-contractor relationship for the provision of care services. It transforms what was an informal family arrangement into a legal services transaction. The care recipient is the employer. The caregiver is the service provider. The care is the service. The payment is the compensation. The agreement is the evidence. For a personal care agreement to be valid and defensible for Medicaid purposes, it generally must include several specific elements. First, a detailed description of the services to be provided. This is not help around the house. It is specific personal care assistance including bathing, grooming, and dressing, medication management and administration oversight, transportation to medical appointments, meal preparation, household management, coordination of medical care, and any other specific tasks the caregiver actually performs. The specificity matters because vague descriptions are easier to challenge. Second, a schedule of when and where services are provided. Days per week, hours per day, location. This establishes that the arrangement is structured and ongoing, not ad hoc. Third, a reasonable compensation rate. This is the element that Medicaid scrutinizes most carefully. The rate must be comparable to what a professional, licensed caregiver would charge for the same services in the same geographic market. This is sometimes called the fair market rate. If the local rate for a home health aide in your area is $22 per hour, that is the range in which the personal care agreement's rate should fall. A rate dramatically higher than market will be challenged. A rate at or below market will typically be accepted. Confirming the local market rate requires actual research, comparing rates from licensed home care agencies in the specific county or region, not national averages. An elder law attorney or a care manager can assist with this. Fourth, payment structure and timing. How is the caregiver paid weekly, bi-weekly, monthly? Payments should be made by check or electronic transfer, not in cash. A paper trail of actual payments, consistent with the agreement's terms, is essential. The agreement says one thing. The bank records must confirm it is actually happening. Fifth, the agreement should be dated and signed before caregiving begins, or if the arrangement is being formalized after the fact, as early as possible. An agreement created retroactively will only protect future payments, not past ones. Payments made before the agreement existed cannot be reclassified as legitimate services after the fact. This is one of the most painful lessons families learn. Waiting to formalize the arrangement until the Medicaid application is imminent leaves the past transfers unprotected. 6. In most states, the agreement should be witnessed and notarized. Some states have additional specific requirements. An elder law attorney in the parent state is the authoritative source on what is required in that jurisdiction. What the agreement does and does not do. A well-drafted, properly executed personal care agreement does several important things. It protects payments from being classified as gifts in a Medicaid lookback review, provided the payments are reasonable, documented, and consistent with the agreement's term. It gives the care recipient a legitimate way to spend down assets, converting accumulated savings into payment for real services, which is a permissible use of those assets under Medicaid rules. It creates a clear record that protects the caregiver from later accusations by siblings, by Medicaid, or by an estate administrator that the money was taken improperly. It structures the relationship in a way that clarifies expectations. What services are provided, when, and for how much. It reduces the single most common source of family conflict in caregiving situations: the sibling who is not providing care, who sees money moving from the parent to the caregiving sibling, and who interprets it as unfair or improper. What it does not do is provide a blank check. The payments must be reasonable. The services must actually be provided. Records must be kept, care logs, service notes, something that documents what was done and when. An elder law attorney familiar with Medicaid standards in the parent state can advise on what level of documentation is appropriate. And a personal care agreement cannot be used to pay a spouse. Medicaid considers all marital assets to be jointly owned, so payments from one spouse to the other do not help with Medicaid eligibility. It also generally cannot be used to compensate the parent of the applicant under most state rules. The tax picture. This is the part that surprises most families. Compensation received under a personal care agreement is taxable income. The caregiver is providing a service and receiving payment for it. That payment must be reported as income on the caregiver's tax return, whether it is classified as employee wages, with the parent acting as household employer and issuing a W-2, or as self-employment income reported on Schedule C, with the potential for self-employment tax, depends on the specific facts of the arrangement and the applicable IRS rules. If the parent is the employer and pays the caregiver more than $3,000 in a calendar year, as of 2026, the parent may have household employer tax obligations under Schedule H, including Social Security and Medicare tax contributions. There are some exceptions when the caregiver is a family member, and the IRS provides specific guidance through its household employer resources, but the rules are detailed enough that a tax professional should be involved. Some Medicaid waiver payments, where the state itself pays a family caregiver through a Medicaid home and community-based services program, may have different tax treatment under a specific IRS exclusion, but the scope of that exclusion is narrow and fact-specific and should not be assumed to apply without professional confirmation. The bottom line for tax purposes: the compensation is real income and must be treated as such. This actually works in the caregiver's favor. In one important way, reported income means a record of earnings, which matters for future Social Security benefits, for loan applications, and for any other context where documented income is relevant. The informal caregiver who is never paid on paper builds no earnings record. The caregiver, under a proper agreement, does. What this means for siblings. In most families with a primary caregiving child, the personal care agreement conversation eventually becomes a sibling conversation, and that conversation has a few predictable versions. In the best version, the siblings understand that the caregiving child has given up something real-time: income, career momentum, personal freedom, and that fair compensation for legitimate services is not the same as a gift or an inheritance advance. The agreement creates transparency. Everyone knows what is being paid, for what, at what rate. There is nothing to speculate about. In the harder version, a sibling interprets the payments as the caregiving child taking advantage of the parent, and the personal care agreement becomes a point of conflict rather than a source of clarity. This is where documentation and the involvement of an elder law attorney at the outset matter most. An agreement that was reviewed by an attorney that reflects market rates and that has been consistently documented is far more defensible than an informal arrangement that was later formalized under pressure. The agreement also does something that most families do not anticipate. It can explicitly address what happens if the caregiving arrangement ends, if the caregiver's own health changes, if the parent's needs exceed what a family caregiver can provide, if a sibling wants to take over. Termination provisions in the agreement create a clear exit process rather than a conflict. The deeper point is this: the personal care agreement is not a financial instrument designed to benefit the caregiving child at the expense of the estate. It is a formal recognition that caregiving is work. Work has value, and paying for that work at a fair market rate is a legitimate, legal, and often Medicaid-compliant way to compensate someone for a service that, if not provided by a family member, would have to be purchased from a professional at market rates anyway. How to get started? The process is more straightforward than most families expect, but it does require a specific sequence. Step 1 is to consult an elder law attorney in the parent state before the agreement is drafted. State-specific requirements vary: notarization, witnessing, specific language that satisfies state Medicaid standards, and the attorney is the only reliable source for those specifics. Do not use a generic template downloaded from the internet without attorney review. A template that does not meet your state's Medicaid standards is not going to protect the payments in a lookback review. Step 2 is to research local fair market rates for the specific services being provided. Contact licensed home care agencies in the parent's county and ask for their current hourly rates. Document this research. The agreement should include a rate that falls within or below this range. Step 3 is to draft, sign, and properly execute the agreement. Both parties should sign. Witnesses and a notary should be present if required by the state. The date matters. Services provided after this date are protected. Services provided before are not. Step 4 is to begin making payments consistently and on the schedule specified in the agreement. Payments by check or electronic transfer only, not cash. Keep all payment records. Step 5 is to maintain service logs, a simple written record of what services were provided, on which dates, for how long. This does not have to be elaborate. A brief daily or weekly log is generally sufficient. The log is the evidence that the services actually occurred. Step 6 is to review the agreement whenever circumstances change, if the level of care increases, if the caregiver's time commitment changes significantly, if either party's circumstances shift in a relevant way. The agreement is a living document, not a one-time filing. A note on Medicaid's consumer direction programs. In many states, Medicaid's home and community-based services waiver programs include what are called consumer-directed or self-directed care options. These programs allow the Medicaid recipient to hire and directly manage their own care workers, including, in many states, a family member. If a parent is already on Medicaid or is planning to apply, and they want to receive care at home rather than in a facility, this is a separate pathway from the personal care agreement and worth understanding. The family member is paid directly by the Medicaid program rather than by the parent's personal assets. Eligibility for consumer-directed programs varies significantly by state, and some states explicitly exclude spouses or minor children from serving as paid caregivers under these programs. This is a conversation for the Medicaid application process, ideally handled by an elder law attorney who is familiar with your state's specific waiver options. It is worth asking about because in some situations, it is the most financially sustainable and Medicaid-compliant solution available. What to do this week? If you are a caregiving child who has been providing care informally and receiving any compensation, even in the form of grocery reimbursements, gas money, or occasional payments, contact an elder law attorney this week. Not to create anxiety, but to understand where you stand. If a Medicaid application is anywhere in the future picture, the time to get the documentation right is now, not when the application is being reviewed. If you are a parent with an adult child providing care, and you want to compensate them fairly, the same apply. Consult an elder law attorney before you begin making payments, or as early as possible after you have started. The earlier the agreement is in place, the more payments it can legitimately document. If you are a sibling watching another sibling receive compensation for caregiving, and you are concerned, the most productive first step is a conversation, not a confrontation. Ask whether there is a written agreement in place. If there is, ask to understand it. If there is not, encourage the family to formalize, one, not to challenge the caregiving child, but to protect everyone involved, including the parent. You can find a certified elder law attorney at nayla.org.